The following is a comprehensive, continuous reporter's dispatch from the Senate Judiciary Committee. It captures the escalating tension, the specific accusations regarding judicial independence, and the legal debates over threats against the judiciary based strictly on the provided transcript details. The atmosphere inside the Senate Judiciary Committee room in Washington today was charged with a level of tension that touched the most sensitive nerves of the American judicial system. As a correspondent observer in the gallery, the first thing one felt was that this was not merely a routine legal procedure, but a high-stakes examination of integrity and institutional loyalty. Senator Blumenthal's opening move went far beyond standard questioning, directly targeting the nominee's capacity to exercise independent judgment. The senator began by characterizing the nominee's previous testimony as nonsense and explicitly stated that the time for such absurdities had to come to an end. At the very center of the exchange was the most fundamental obligation of any judicial candidate, the duty to tell the truth. The sharpness in the senator's voice, combined with his insistence that the nominee demonstrate a capacity for judgment regarding independence in reality, caused the room's air to thicken instantly. The senator utilized highly concrete and unavoidable questions to corner the nominee, suggesting that if a candidate cannot sit before the committee and plainly state that Joe Biden won the election or that the Capitol was attacked, there is effectively nothing left of their capacity to serve as a judge. This line of questioning was not just a historical inquiry, it was a scale designed to weigh the nominee's resilience against potential future pressure scenarios. The senator pressed further, asking what would remain of a judge's integrity if a difficult case arose in a future administration, specifically a Trump administration, leaned on them or exerted executive pressure. The question of how plaintiffs and defendants could ever believe they would receive a fair trial and a fair decision remained unresolved, overshadowed by what the senator called the nonsense answers provided by the nominee. While expressing a personal sense of regret for having to deliver such harsh critiques, the senator did not dial back the intensity of his accusations. The implication of dependency on executive branch leaders, specifically figures like Ms. Clark, was presented as a major blow to the nominee's perceived impartiality. Furthermore, the mention of powerful political figures like Lindsey Graham, noted as a friend of President Trump and the likely next chair of the Judiciary Committee, served to illustrate the sheer scale of the political pressure cooker the nominee is operating within. The senator emphasized that he would not make a fool of himself and that the answers should be simple and honest, ultimately expressing a profound sense of disappointment. As the minutes ticked by, the debate transitioned into a more technical and legal dimension, yet the tone of severity remained unchanged. Questions regarding threats made against judges pushed the boundaries of legal liability. A scenario was debated involving a threat to a judge's life or family, questioning whether liability should be restricted solely to the individual speaker or if it should extend to the structures that organize or incite such threats. The nominee's admission, speaking from a prosecutor's perspective, that a chain of responsibility could indeed exist in threat cases, shifted the debate into new territory. The senator emphasized the gravity of the issue by noting his own monitoring of Supreme Court justices and members of the 9 circuits. Referencing the nominee's background in the Court of International Trade, the senator suggested that while such threats might not be common in that specific venue, the legal basis for investigating them was robust. The discussion expanded to include racketeering laws, conspiracy doctrines, and the RICO statutes used in combating organized crime. The nominee agreed that liability could technically extend beyond the person uttering the threat and expressed an intent to be guided by federal laws and doctrines. However, for the senator, these technical concessions were insufficient. Contending that federal judges are currently living under the shadow of the worst physical threats in the nation's history, the senator alleged that the Department of Justice and the U.S. Marshal Service were failing to adequately investigate the evidence behind these threats. Specifically using the phrase right-wing conspiracies, the senator argued that when investigators begin to look behind these threats, they often abandon the search or refuse to verify findings for political reasons. He explicitly claimed that the Marshal Service was unwilling to follow through because the investigations would lead toward politically sensitive entities. This grave accusation suggested that even the physical safety of judges has become a subject of political maneuvering. Throughout the session, the theme that the nominees' answers lacked simplicity and honesty was repeated. The nominees' reliance on their experience in international trade court was framed by the senator as a weakness, a sign of either a lack of experience in criminal law or an unwillingness to confront federal threats head-on. Every question acted like a sword strike, testing not just the nominees' knowledge, but their ethical stance under political duress. The senator's final lament, "They won't answer this," reflected a belief that the system is gridlocked and that truths are being suppressed. All these dialogues formed a raw portrait of the deep mistrust between state institutions and how political polarization has seeped into the judicial bench. The tension throughout the text was fueled by the conflict between the nominee's attempt to defend a professional career and the senator's tendency to view the nominee as a political pawn. Ultimately, this session was less about a single appointment and more of a harsh, accusatory lesson on the unyielding nature of justice in the face of executive power. The nominee's perceived inability to speak the truth was coded by the senator not just as a preference, but as a danger to the future of the judiciary. In the continuation of this report, the disappointment felt by the senator deepened as the session progressed. The speaker presented the nominee's stance on events etched into the national memory as a test of independence. For a judge to struggle with acknowledging events that constitute an attack on basic democratic processes meant, in the senator's view, that the individual had lost their judicial capacity entirely. This was not merely an accusation of legal inadequacy, it was a direct assault on character. The senator stood before the nominee and repeatedly asked how someone who cannot acknowledge simple facts would show resistance if the executive branch pressured the court tomorrow. The labeling of answers as nonsense stemmed from the perception that the nominee's sentences were designed to circumvent real issues rather than address them. The specific invocation of names like Ms. Clark and Lindsey Graham reinforced the suggestion that the nominee's professional future was mortgaged to these political actors. The senator stated, "I don't need to make myself ridiculous," implying that the nominee's behavior was a transparent attempt to hide a truth everyone could see. When the debate shifted to the axis of threats and responsibility, the gravity of the situation increased further. In an environment where the lives of judges and their families are at risk, the boundaries of legal liability were scrutinized. The nominee's theoretical agreement that those who are part of a conspiracy or an organized structure could be held liable was far from a consolation for the senator. The real issue was not the existence of these laws, but the will to apply them against certain groups. By claiming the Marshal Service and the DOJ were abandoning investigations into right-wing conspiracies, the senator alleged a deep-seated fear or bias within the institution. This accusation that those responsible for protecting judges prefer to protect political balances hung in the air as one of the darkest claims of the hearing. Consequently, what was spoken in this session was a reflection of the nails being driven into the coffin of judicial independence, or perhaps a desperate attempt to save it. The senator's disappointment was not just with one person's performance, it was a reaction to an integrity crisis within the system. Every line of the transcript carried the weight of mistrust born from the nominee's past answers and the fear of how that mistrust would shadow future judicial rulings. The claim that the nominee's international trade experience would be insufficient in the face of criminal law and constitutional crises turned even their professional qualifications into perceived flaws in this political storm. As the session concluded, what remained was a nominee whose honesty and courage were under fire, and an angry senator convinced that the gears of the system were turning to protect the executive rather than the truth. The nominee's demeanor throughout the hearing was elevated by the senator to a point that could be described as the art of concealing the truth. The speaker repeatedly voiced that he could not reconcile the nominee's avoidance of taking a clear position on sensitive political issues with the dignity of a judicial post. A judge's refusal to confirm obvious facts, such as election results or the attack on the Capitol, amounted, in the senator's rhetoric, to the end of judicial capacity. The logic employed here was incredibly stark. How could someone who cannot state the simplest truth be expected to establish justice in the most complex legal cases? The senator's accusation that he was truly sorry that you had to give these nonsense answers suggested that the nominee was under a form of captivity. The source of this captivity was pointed toward executive branch leaders and the powerful figures of the ruling political bloc. The naming of influential senators like Lindsey Graham fueled suspicions that the confirmation process was a demonstration of loyalty rather than a merit-based evaluation. The senator argued that the nominee's dependency on these figures and the political power they represent would fundamentally undermine the right to a fair trial. The question, "What will remain when the executive branch leans on you?" was a fundamental inquiry into the very raison d'etre of the judiciary. If the judiciary is to be crushed under the weight of the executive, the legal guarantee of the citizen against the state would vanish. This harsh and accusatory tone was a rebellion not just against the individual, but against a new profile of a judge who lacks a public backbone.
In the deeper legal sections of the discussion, the alleged unwillingness to investigate threats against judges took center stage. While stating that federal judges are facing a wave of physical threats unprecedented in history, the senator argued that this was a deliberate omission rather than a security failure. When the nominee, who has a background as a prosecutor, was asked about the responsibility of the inciting structures behind a threat, the technical answers provided did not satisfy the senator. While the nominee's acceptance of complex legal frameworks like RICO and conspiracy doctrines appeared correct on paper, the senator's primary concern was the will to exercise those laws. The critique of the U.S. Marshal Service merged with the accusation that the institution avoids cases that touch upon sensitive political structures. The phrase right-wing conspiracies sharpened the political color of this accusation. The senator argued that judges were being left alone in the face of these threats because the political connections of the threateners intimidated or halted investigators. The nominee's emphasis on international trade court experience was viewed by the senator as an escape hatch. In a period where criminal law and constitutional rights are under such attack, the nominee's lack of experience or silence in these areas was presented as sufficient reason for them not to take the bench. The call for honesty and simplicity that persisted throughout the session went unanswered with every response from the nominee. In the senator's eyes, the nominee became a symbol of executive pressure over the judiciary, rather than just a legal professional. Every dialogue recorded in this text stood as a heavy indictment, jeopardizing the nominee's confirmation and opening their independence and courage to debate. Ultimately, the message that the ability to make a fair decision is not just about knowing the law, but about defending the truth at all costs was etched into the minds of all as the main theme of the hearing. In the final act of this escalating debate, the senator's accusations against the nominee reached a level suggesting institutional betrayal. The nominee's sacrifice of the perception of reality, the most fundamental building block of justice for the sake of political maneuvering, was portrayed not just as a disappointment, but as an axe swung at the roots of the system. The senator implied that every file and every testimony placed before the nominee was an integrity test, and the nominee had failed. In a scenario where the shadow of the executive branch is so prominent over the judiciary, the impossibility of an independent judiciary was emphasized. The influence of figures like Ms. Clark and Lindsey Graham over the nominee's career path was presented as a control mechanism. This created the fear that the judge would feel a debt not just to the laws, but to the political powers that served as their reference. The senator's call to be simple and honest was a critique of the nominee's complex inability to answer. Regarding the threats against judges, the situation became even direr.
At a time when judges' lives are in danger, the senator presented the failure to pursue the structures behind these threats, particularly right-wing conspiracies, as a dereliction of duty by the DOJ and the Marshal Service. The nominee's technical and distant stance was seen as a proof of an inability or unwillingness to ensure the safety of judges. For the senator, the issue was no longer just an appointment case. It was a demonstration of how the judicial system, which should be the protector of American democracy, has entered a spiral of silence under political pressure. Every question, every accusation, and every grievance turned the confirmation process into a trial. By the end of the session, the nominees' evasive answers and the senator's anger at them were recorded as one of the sharpest confrontations in American political history. The nominees' hesitation to tell the truth created the greatest doubt about their fitness to dispense justice, a doubt that echoed like a recurring refrain throughout the entire proceeding. Every second of this session highlighted how vital a backbone is for a member of the judiciary. Senator Blumenthal's arrows, aimed at the nominees' professional past and potential future conduct, targeted a mindset rather than just a person. The phrase "nonsense answers" was described as one of the heaviest shackles on a judicial candidate's dignity. If a candidate already feels the weight of the executive branch so deeply before even taking the bench, how could they protect their independence once they don the robe? As this question echoed through the halls, the nominees' silence or convoluted responses were perceived as evidence reinforcing the senator's claims. The assertion that physical threats to judges are driven by right-wing conspiracies and swept under the rug by the top levels of government turned the hearing from a legal debate into a crisis of national security and integrity. The senator presented the Marshal Service's reluctance to finish investigations into politically sensitive areas as a gamble with judges' lives. The nominees' avoidance of these dangerous waters, seeking refuge in the safer harbors of the International Trade Court, was interpreted by the senator as a sign of cowardice or partisanship. Every word and every accusation acted as an obstacle on the nominee's path to confirmation, and the senator's expression of disappointment became an outcry of the deep fear that, in the end, politics, not justice, would prevail. This text concluded as a record of these dark and tense moments in American judicial history, proving with every letter how essential the demand for honesty and independence truly is.